today's session, Considerations for the Management and Administration of Digital Legacies, and our presenter is Daniel Nelson, whose legal practice focuses on estate planning and administration, as well as legal services for designers, web and social media developers, and gaming firms. And just a quick thanks to our sponsors, the Center for Innovation Law and Policy, Lawyer Locate, My Support Calculator, Barcode Realty, My Legal Briefcase, and Cobalt. So without further ado, Daniel.
All right, so thank you all for coming on this beautiful day when we would much rather be outside. Mira, no? I don't know. I think I'd much rather. I think Mira and I were saying just before we should really just take this out onto the garden and sit in a circle and talk about it. I think that might be a much better idea. So we're talking about this great big long title, but really what we're talking about is what happens to our digital life when we die, which is becoming more and more of an issue as we pour more and more of our lives online. So by way of introduction, as Mira indicated, my practice is primarily in estate law and sort of new media tech people. I teach in the School of Design at George Brown College in design management and in game design, which is lots and lots of fun. So I get to see games that long before they ever get out to the marketplace, or at least hopefully before they get to the marketplace. Certainly they all have dreams of getting their game out to the marketplace, but may not have got there yet. You certainly detect a trend. Everything seems to involve shooting things. We haven't been able to get games beyond shoot 'em up games. I guess that primarily the teenage male user and the teenage male producer of these things, we can tell where their minds are. So what do we mean by digital legacies? It's, as I said, the digital footprint. So what is it that we have digitalized that has no physical presence online? So it could be your email account. It could be the stuff on your memory stick or your hard drive. It could be your social media accounts, Twitter, Facebook, Flickr, Pinterest, whatever the latest hot social media account is out there. The massively multiplayer online role-playing games, which are these huge online games. Anyone a player of such games? There's 2 of us, 3 of us. So these are these mammoth games like World of Warcraft, Diablo, which just came out. These huge games, you access them for the most part online through a gaming system or occasionally a computer. You think, yeah, whatever, who cares? But there's mammoth value there. And we'll talk about that. Domain names. You may have heard a few months ago, here in Ontario, a court decision called Tucows v. Renner, which established that a domain name is indeed property, at least with respect to the case, the matter at hand, but certainly we can extrapolate out to say that domain names are certainly a form of property that has value. Of course, the big thing is if you don't have the email account, it's almost impossible to claim it. So what else? What have I forgotten? Movies on, yeah. So your YouTube account, the content of it, for sure.
My
fan fiction.
My iTunes music.
The iTunes music. So that's you paid for it, but it's a license, and that gets into a gray area of whether or not you get to keep the license or not. Obviously, iTunes would prefer that your iTunes account dies with you, right? Anything else? Blogs, yeah. But even more so, it doesn't have to be, most of what we're talking about has been social media stuff, right? But it can be your digital legal stuff. The gentleman who were talking here in this lecture hall a few minutes ago, all of that stuff is online in a cloud. That's a digital asset. Your financial information, your web-based business there may be no bricks and mortar physical presence to your web business. The other big thing, online currencies, bitcoins, for instance. Most of the big games that we were talking about, the MMORGPs, have internal currencies. Second Life has an online currency called Linden dollars, and most of these currencies are traded externally. You can convert your Canadian dollars into Linden dollars. It doesn't have a great exchange rate, but certainly you're capable of doing so. And bank accounts of some kind, or sorry, not bank accounts, but non-bank accounts of some kind. So your online gambling account. Maybe you go online and gamble, and if, like most of us, you're probably spectacularly, it's a money-losing venture, but if you're successful, you might have $5,000, $10,000, $100,000 hiding in one of those accounts. Yeah?
You might include there just access rates.
Yeah, well, I mean, I'll talk about access rights later on, but at this point, I just wanted to sketch out sort of the things that we're talking about. So bitcoins, Linden dollars, online gambling accounts, and there's very good reasons why people hide things online, right? I mean, you have a spectacularly good hand in poker or whatever it is, and you win a lot of money. You don't necessarily want to pull it out. You keep it online, and then you get run over by a bus the next day. You win some and you lose some, in other words. Anything else? So in addition to the sort of the obvious stuff, these more esoteric things, any other thoughts that I've forgotten?
What about digital relationships?
Well, what do you mean by you mean online? You mean like a personal relationship, like love relationships? Well, you've got stories coming out of Southeast Asia about people going online and marrying basically computer programs, right? These robot isn't quite the right word. I'm drawing a blank on the right word, but yeah, no, I mean, obviously that computer program doesn't have the capacity to enter into a marriage contract, at least in the real life sense, but who knows? Absolutely.
Any community profiles that you have?
Well, exactly.
Community profile where you posted more than just outside of Facebook, but if it's a specific interest
Yeah.
that you have.
Or and sort of putting those two ideas together, things like, LoveCupid and plentyoffish.com and these online profiles. But what if your client, if you're a lawyer, has a Ashley Madison account, which, if you don't know, Ashley Madison is a website for people who want to cheat on their partners. It's a place where you go to cheat. Obviously, that's reputation management, right? So what do you do with that online asset? Do you turn that over to the wife who is the beneficiary? Who knows?
It might be useful to consider that most of these questions arise in cases of disability as well as death. You may not
Sure.
quite the way you find out about when you're in an
Well,
mental
fair
illness.
enough.
But if you're in the home and she's taking care of you,
But yeah, absolutely. And it may not be Ashley Madison. It might be, God forbid, illegal digital content, right? Illegal porn of some kind, which, again, what do you do? How do you manage that bombshell? So why is this important? Well, at least for Canadians, we are amongst some of the heaviest users of online content. So this is just something I pulled off of the web the other day from the Globe and Mail. The highest penetration of internet access. We spend more time online than anyone else. We consume more YouTube content. Highest penetration rates on Facebook. The largest block of Wikipedia users. So we are, as Canadians, jumping into this world with both feet. And as the reality is that this is ultimately generational. Younger people are likely to have produced the most digital content. That may be a problem, but certainly as older, the fastest age group on Facebook is older Canadians. So this is only going to become more and more of a problem. So I just to loop back, I should say, just because I have a PowerPoint presentation, please, I'd rather this to be more of a conversation than a debate. So don't feel that just because I'm up the front with a podium, that means I'm master and commander. So jump in, feel free, please. So blah, 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 this is sort of what we've come up with as a definition for digital assets, as only a lawyer could possibly do. So I apologize to all the non-lawyers in the room, but effectively what we're talking about is an enforceable, incorporeal personal property interest created, maintained, and stored in a digital format, such as a ROM or flash memory device, and accessed using a computer directly connected to that memory storage device or remotely via the internet. So we subdivide that into two categories. One, physically controllable digital assets. So the asset is controlled by the thing that holds it or contains it, the memory stick, in other words, the hard drive. We then also subdivide it into the other kind, which is controlled access digital assets. So that's the kind of asset that you have access to remotely, cloud-based. So logging into your Gmail account, your Facebook account, your Twitter account, right? All controlled access. So the challenge with physically controllable digital assets is that you have the digital asset, whatever that happens to be, and you have the storage device used to contain it, right? The digital asset can't exist in the real world. It has, unless you hit print, either a paper printer or a 3D printer, and then you have the machine, the device that holds it. But we have to distinguish between the ownership of the digital asset and the ownership of the device that holds it. So it's certainly possible, for instance, to have a scenario where your personal digital asset is stored on your boss's computer, for instance, right? And the ownership is of those two things are separate and can create a huge headache. Controlled access digital assets, on the other hand, of course, are those that are cloud-based. You have no physical access to the machine that it ultimately is stored on. So you go online, you log in. Obviously, somewhere in the world, the data is being stored on a server somewhere, but your only direct access to it is through a user authentication process, which is usually, in most cases, a username and a password, right? It might be free. You might have to pay for it. And most of these, if the service provider has dealt with this, and many haven't, if you read the fine print of their end-user license agreements, most of them, let's take Facebook as an example. Facebook doesn't claim intellectual property ownership or license in the content. They don't claim that they own your photos. They don't claim any of that. But on the other hand, they govern access. You are prohibited from letting someone else use your account, and you are prohibited from sharing your username and password, which, for the most part, is fine, but then you have a collision course with, when someone dies, with the executor, right? In Ontario, under the Estate Administration Act, the executor takes automatically. Basically, as soon as you die, if there's a valid will, the executor now steps into your shoes. You are, you as the executor now have control. So at some point, eventually, we're on a collision course between these two competing interests. Although I would suggest that obviously the statute should trump an end-life user agreement.
Website can be considered like a digital asset.
The website?
Yeah.
For sure.
And what kind of this?
I'm sorry? I can't hear you.
It's accessible for everybody, not protected by password, not stored on flash drive.
Yeah. If the decedent owns the website itself, then that's relatively easy because they own that website, right? They obviously have to pay for domain space, but they own the website. The challenge is when you have the content behind a wall. So your Facebook account, say for whatever reason your Facebook account has huge sentimental value, tragic death or something. the executor may want that content extracted out of that Facebook account. To do that, they either have to masquerade as the decedent and simply pull it out, contact Facebook and hope they will do it, and they generally don't. Facebook has what's called memorialization, which they'll memorialize your Facebook page, basically lock it down so no one can access it, but it remains so people can post thoughts. I'm thinking of you or whatever, in a sort of modern take on going to the graveyard, I suppose, and leaving flowers. Hey, it happens. Go if you're on Facebook. If you can, you have to know somebody who's died. But chances are, if you know someone who's died and they've gone through the memorialization process, you'll see. And it seems my impression tends to be that it's younger people who are more into posting on Facebook as a way of memorializing and remembering their friend, as opposed to older people. But I don't think it's universal. Did you want to?
No, there's lots and lots of sites that do that. There's actually memorial sites.
Absolutely.
I would not limit that to a generational thing.
No. I just mean,
they're very popular.
Yeah, with respect to just Facebook, my impression tends to be younger, but that's an impression only. You're absolutely right. There's a whole bunch of them. Some of them are standalone. Some of them basically sell their services to funeral homes, so that if you go to the funeral home webpage to learn about the funeral arrangements, they'll have a memorialization page. I know when my grandmother passed away last year, same process. I thought, as someone who is online a lot, I was shocked at how bad it was and how cumbersome it was. But those are certainly out there, and they vary widely in terms of their success and use. Anything else? So I'm not very good at this in the sense that I don't slavishly follow a PowerPoint. I just sort of start talking and then use it. So we've talked about all of this already, but the other, of course, is the conflict of laws problem, where you're dealing with multiple jurisdictions. So Facebook, of course, to continue using the same example, is based in California. The decedent, of course, let's, for hypothetical sake, argue that the decedent is based on Ontario. So does California law apply? Does Ontario law apply? One of the ways that people have started to think about how to deal with this are the various legacy services. There's a whole bunch of them out there. Legacy Locker is one. Entrustit is another. Entrustit was just purchased by a large European firm whose name escapes me at the moment. I have, not that it's a conflict, but I do know the people who run Entrustit. All of these services, they're online password and username storage services. Yes?
Just one question about memorialization. What's phase? I'm curious. What about access by public authorities to the account of someone who has died? For example, terrorist dies. He blows himself or she blows herself up. Could the authorities have access to his or her Facebook account after death?
I'm sure that if that was necessary, the relevant authorities would go to court and simply get an order to compel whichever organization to do that. We see it all the time. It doesn't necessarily have to do with memorialization, but certainly organizations like Twitter and Facebook have faced lawsuits to reveal user information. There was just the other day news that Twitter was trying to fight back on a similar order regarding the Occupy movement. And so I would imagine that it would be no different. It's just that with memorialization, what they do is that once the Facebook is satisfied that they're dead, and that's a whole other issue, that what happens if someone just simply calls up or emails Facebook and says, this person's died, and here's a link to his obituary, and Facebook dutifully locks the account, but you're perfectly alive. I don't think they have fully thought out. Most of these tech companies haven't fully thought out all of what that means. So, yeah, sorry.
So just a question about legal persona. Death may not actually have to be a person, but an entity could die. I had this experience myself where I had a corporation that died, and I would have liked to have memorialized the digital assets of that, maybe for later revival, but whatever. Is your thinking equally applicable into a legal person that's not a person?
Well, in some respects, it's not different in that so long as someone keeps paying the account, the domain, pay for the domain name and the web hosting service, if you just keep your mouth shut and you as a person continue to manage the Twitter account, the Facebook page, or whatever, then no one's the wiser. You can simply argue that you are.
For legal reasons, it has to shut down to public access. But
I'm not sure.
But keeping the digital assets, that stuff all got lost. And so my question is, whatever you're getting to here, is there a kind of a right to?
Well, it would be. I would suggest that it's no different than an executor, right? The whoever is winding up and liquidating
and
the.
Now Facebook business pages as an example, right? So you would run into that scenario where the entity ceases to exist.
So I don't think Facebook has a memorialization option for business. I think you would have to just simply keep it. You as a person would have to keep it active, and on the it's easier to ask forgiveness than permission principle. That's not a legal answer, but I'm not sure there's any other solution. Certainly, I think it would be a hard sell to convince Facebook to memorialize business pages. I'm not sure, but I could be wrong. So these online digital legacy services, it's basically the Wild West out there. It's caveat emptor. There is no standards, no rules. There's all kinds of them out there. They vary widely from very professional websites like Legacy Locker and Entrusted to guys that have thrown up some super basic site with basic HTML that looks circa 1994. And you wonder why anyone would give this website your username and password, but presumably people are. Some of them are free, or some of them have the basic service for free, and then, of course, you have to pay for additional services. Some are, they have different business models. The challenge with them is that, of course, I'm sure everyone in the room can agree that it's your accounts come and go, right? You change accounts, you change your username, you change your password. All these things are hugely dynamic, and so a legacy locker is only going to be as good as your diligence in keeping it up to date. And we all know that that's not very likely. The other big problem, of course, is they're not legally binding. Unless you have a will, whoever you name in that system, I should back up. So how it works is you log in, you create your account, you add all of your accounts that you want to have access to, you add the username and the password, and then you indicate what your wish with respect to that account is. Deletion, extraction, maintenance, or all of the sort of various potentialities. Then once the legacy locker, Entrusted, whatever company receives notice of your death, they then release that data to the person that you've named, sort of a digital executor in effect. Of course, but that's not legally binding. You may not have had a will, in which case it's theoretically possible that the decedent's personal representative has gone to court and been made an estate trustee without a will, and that is an entirely different person than the person that you happen to have named in the legacy locker 5 years before. And so if you really have to use these systems in conjunction with a will in order to make them really useful. The other big problem, of course, is that if I just finish the thought, is that if they accidentally release the information to the wrong person, they could in effect become an executor de tort, which means that they're legally liable and held to the standard of an executor, in which case they could see significant liability depending on what they did. And they have completely not thought about that issue. Sorry, there's 2 questions. Who wants to go first?
I'll go.
All right.
We can jump ahead. You said, the legacy locker will depend entirely on the diligence of the person indicating what accounts they have and what the passwords are. And I think I'm prepared to go out on a limb and say that most people are not going to maintain it properly.
I'm out on that limb with you.
Right. So I think, as responsible lawyers and thinkers, we should just take that assumption forward and say, okay, so you're an executor. You don't know how many email accounts and what the passwords are that the deceased has, and you really need to find that increasingly because so much critical information is coming through the emails these days and into the future. So I guess we'd have to find some way of opening that up. If you can prove you're an executor, that you can take your proof and really go fishing, I suppose, with it
absolutely.
to find out where stuff is.
I don't know about all of them, but I do know that Entrustit, for instance, offers basically a trolling service. You give the name and any sort of information you have, and they go out and they troll the internet to find accounts for you. It doesn't have the password, of course, but they at least find the accounts for you. And they, of course, charge for that service, which I don't remember at the moment.
If somebody dies and they don't have their regular will, but they have, it's not my area, but wouldn't this kind of be like a digital will, essentially? Like there's clear intent there.
It could be considered a non-binding memorandum. I mean, there's a bunch of problems. It isn't witnessed. So if it isn't witnessed, then it has to be in your handwriting to make it a holographic will. Well, obviously, it's not. So that's the big problem. Also, it's barred by statute. So in Ontario, the Electronic Commerce Act specifically excludes wills and codicils and powers of attorney. So they absolutely must physically exist on paper to be valid. So it's, at least for the time being, a digital will can't exist. It's a nullity.
That's the e-commerce act?
Electronic Commerce Act.
But your executor is empowered to do anything that you would have done. So you don't need a specific digital executor.
No. No. But the problem, of course, is that you have to have that executor, or else, of course, go to court to be appointed a. So for the non-estate lawyers in the room, the old terms are executor and administrator, meaning that you died without a will. The new terms, of course, are estate trustee with a will and estate trustee without a will. And I tend to flip back and forth and use them all, so I apologize. But that's essentially what we're talking about.
So is it going to be very difficult if somebody dies without a will, like it is if you die with a lot of other problems, but is it going to be more hassles from a digital standpoint?
I think they're going to be hassles whether you have it or not. But certainly...
Speaking of children, like parents of children, what's the average age a person takes a will? Maybe not until they get married, so you've got a lot of... They're getting married, I don't know what the average age of the person has a will, but maybe 30. So as a parent, they die, then they don't have a will, who has control over their Facebook and all their accounts?
Well, the big problem is delay, right? Because you have to go through a rather elaborate process to get appointed as a state trustee without a will. You have to have all the other beneficiaries renounce their interest and agree that Mr. X takes on that function. So it could be months and months before the estate trustee without a will is appointed. So if nothing else, there's a much more of a time problem if you die without a will. In the meantime, people could be starting to intervene and do things, even in the goodness of their own heart, that are going to cause problems. You may not want to memorialize the website, but some friend could simply send off an email to Facebook saying, "This person's died. Here's a link to their obituary on or their memorialization website or the funeral home death notice," and Facebook just okay, and Memorial locks down your page.
On Yahoo's terms of service said as soon as we found out you're dead, all is closed, all is deleted, which is fine. That's not only your email, but that's Flickr, that's a whole lot of other things that Yahoo groups, goodness knows where.
Well, and that may well be in response to a case a few years ago in Michigan, a Michigan surrogate court, where a guy by the name of Justin Ellsworth died. He was a U.S. soldier, and he blogged about his experience in, I can't remember if it was Iraq or Afghanistan. He, of course, but he was sadly killed over there. And his family had been asked. He had asked his family to save it and to keep it, and so they went to court to force Yahoo to release that. The compromise solution was that they didn't give access to the blog and the website. They simply presented a DVD with the content. But that creates, and that's certainly a reasonable one. That's certainly what I expect what courts would start to do as they intervene, because it's a reasonable compromise between the service provider's desire to control access and the executor's right to the content. So, but that creates its own problems. I mean, if he had a blog and it was hugely popular, and all these people came to it and they wanted to keep it going and maintain it and keep blogging on it and keep talking about stories related to Afghanistan or Iraq or other soldiers who had been killed or whatever the family wanted to do, they effectively had to rebuild it from the content on a DVD. Yeah.
An interesting corollary to this is if an executor can just take control of a decedent's primary email, then he can recover passwords from virtually any service.
Yes.
Using the forgot my password.
Yes, absolutely. On the as I said before, on the easier to ask forgiveness than permission principle, which certainly isn't legal, but certainly is faster and easier, right? Like if you're particularly concerned about extracting that $100,000 out of the gambling account or whatever, you might just choose to look the other way. Not that I would, as a lawyer, advocate such a breach, but.
An executor steps into the shoes of the deceased, though. Doesn't that include and has an obligation to
Absolutely.
hold the assets and pay
Absolutely.
debts? I think there's a color of bright. If you look at the criminal code about unauthorized access to computer accounts, it says without color of right. I would have thought being the executor is a color of right. Now, being the person who in 9 months will be appointed the executor, the administrator, will. By the time the criminal charge goes through, you'll have got that. So your color of right.
But the service providers don't take that viewpoint, is what I'm saying.
That's right, which is why you get legislation.
Yeah. Yeah. Oh, sorry.
You hear occasionally people blogging about this and saying maybe everybody should have a digital executor. And I've just been sitting here and thinking about that. That would be really kind of an awkward idea because we live online, and all those, all that information, the financial information, banking information, bills, all that kind of stuff comes through the email accounts increasingly, and your access to the data you need to pay those bills and run those finances are all online. I could just see if you're trying to delineate which of the executors is going to do what aspect. What a nightmare. Doesn't seem to me like a good idea.
I agree. The only thing that might be advantageous is taking the concept of primary and secondary wills. You don't necessarily want that information probated and made public. So, if for those who aren't estate lawyers, you can create these things called primary and secondary wills. Primary wills are the one that go to probate. Secondary wills cover everything that doesn't require probate, and arguably your digital online content may not need probate. So you can certainly put those instructions into a secondary will, or even create a secondary will, appoint, it may be in fact the same executor, but appoint an executor for digital assets, and then create more detailed instructions in a non-binding memorandum to guide the executor. That's certainly more complicated. You're absolutely right. I don't think it necessarily has to be, but that was certainly one of my thoughts. And if you wanted to provide information without making it public, but still be part of a will, that was my thoughts on how to deal with that. Particularly if it's maybe business related or financial related. It's obviously going to be driven by the client, right, and what they need and what their digital assets are. Certainly, if it's just a guy who has a Facebook page and a Flickr page, then why bother?
Would you have to, when you're passing accounts, would you have to actually list all of the digital assets, however, or I guess we don't know that.
We don't know
I mean,
yet.
if they have no value, if they're simply
Yeah.
communications meetings or something.
And the challenge, and my colleague Jerry Gertner, who was originally going to be here with me, he comes at this from the forensic accounting side. So he's really into the valuation and extraction side of it. That's not something I know a great deal about, but certainly that's another whole issue: is how you value these assets.
Well, it can be a real issue for those, thinking of the online gambling account. Nobody knows about it. So when you come to do probate or even the final tax return, how detailed does CR get? What if the executor don't know there's an online gambling account?
Well, and that's one of the new risks that executors face, is the executors now, their obligation, their legal responsibility is to claw in all of those assets. And if they overlooked $100,000 sitting in an account somewhere, the beneficiaries would probably take a rather dim view of that, right?
Yeah, you want to be able to close the accounts.
And yeah, there are lots of things in wills, such as you only recognize children who are born in a legal marriage or the parents have shown a demonstrable, because you want to exclude the children that might be out there that no one ever knew about, and you have to be able to close your accounts at some point. And the same thing here. How do you need to develop some sort of a practice, good practice, to say, right, I've done the scan, I've gone to entrusted, and I've done everything reasonable.
And I'm part of a team that's starting to work on that, because that's the next step, right? Is figuring out what the professional standards are, and how we're going to deal with that.
Where is that team?
There's at this point, it's a loose team of people who are interested in the topic here in Canada that are working on it.
I was going to say, on the value point, that value can be totally different depending what value you're looking for, right? So there's monetary value, or there's
sentimental.
Having a blog that generates ad revenue long after you're dead because it's automated by Google AdWords, so it's just accumulating money, and at some point,
when you know,
your family and children are going to want that $10,000 that's accumulated. And on the other side, things like there's all sorts of cases where people have died and their family is unable to access, like family photos of their children, or there's photos you want to take down. Like there's a case from the States where, a woman was murdered and by her boyfriend, and there's pictures of them together, and the family wants
the
to
Oregon?
get those down.
I think it was in Oregon. Yeah.
Well, I was just thinking the idea of a literary executor is not unusual if your world is writing books and poetry.
Yeah.
And so in this case, if your world really is blogging and making money off the internet,
it would totally make sense.
Why wouldn't you have a digital executor as someone who can knowledgeably administer the wills that the wishes you're expressing? So,
absolutely.
I think it's actually a good opportunity for a business for somebody who knows what they're doing.
There you go. So if you know anyone, I'm happy to be hired.
Well, I think, just on that point, I think the meaning of literary executor would have to extend if you are a writer and one of your media is on an online media, then I think that would fall into the literary executor's mandate.
Look at the explosion of ebooks, right? I mean, there's that girl in, where is she? A young woman, I should say, who writes vampire fiction, and she's reached $1 million on these ebooks that she self-published, right? 20 years old or something. Clearly I'm in the wrong business. If only I knew more about writing about vampire fiction. Sorry, yeah.
Will cannot be digital. Due to the progress of medicine, we now can give a reasonably good life to people who are, for example, completely handicapped. I'm thinking about people like Stephen Hawking. 50 years ago, he would have been dead a long time ago. But how can these people transmit their property, their belongings to other people if they cannot sign a will?
Well,
so I'm thinking about developments in technologies such as voice recognition and so on, which could be, I think, extremely useful.
You would simply use and these date back centuries, but essentially there are ways in which a will is dealt with if the person's blind or whatnot. They simply make their mark, and there's a statement inserted into the will that this is their mark, and the witnesses agree that that was his mark or her mark. So literally an X is sufficient, right? Which dates back to people who were illiterate, right, or blind. I would imagine that would be until the law changes. Wills are one of the most ancient forms of law that still really exist, and one of the principles is that you have one original signed copy, and if it's destroyed, there's a presumption presumption of revocation, which means that if it's destroyed in some way, it's gone. That's what's driving the philosophy or the theory that it has to be one piece of paper signed by the testator. So Stephen Hawking's, well, it would be typed up. He would simply make a mark, and there would be a signing statement.
You cannot make a mark. That's like
Well, yeah, or some other signing statement to deal with that would be how it would be handled, just like someone who was blind. It's not a huge issue. Certainly the law has dealt with similar problems, and it would just be, so long as there's some identification that some process that they're saying, this is my will and I'm committing to it, and the witnesses are there, present, and agree that that was his intention, then that would be sufficient.
Multi-jurisdictional issues going to grow and grow? If you think of U.S. law and with the internet, you're all over the place. Like, you may have a Canadian will, but is it going to be recognized?
Well, but this isn't. That's not a new problem. It's people have property in multiple jurisdictions. So, how it works is that real property is governed by the law in which the real property is present. Everything else, personal property, is governed by the place where the person dies and where it's probated. So, in that sense, the probate process would be driven by, if they live in Ontario and they die in Ontario, and we go over to Queen University for probate, it would be governed by Ontario probate law.
Yeah, but then don't you have issues with taxes because in the U.S., based on a percentage of where your property is, does that come into play? Because if you've got...
Yeah, I don't touch tax with the 10... I mean, that's the accountant's job, so I'm not going to give you an answer to that. But yeah, it's a huge problem for sure.
Just to comment on that, it's a difficult issue with international law. When you have conflicts of law, you have conflict rules. But the problem is that those conflict rules will not necessarily bring a solution to the conflict. You may have perfectly contradictory rules to live with.
And there is
taxation is one specific example.
And there is an international convention on
that's why you have
wills.
Conventions, but
but that only governs the validity of the will document itself, and there's very few signatories. Canada and specifically Ontario, Canada is a signatory to the International Convention, and Ontario operationalized it in the Estate Administration Act, but very few countries around the world have signed it, unfortunately. Who wants to go? Duke it out.
I have a quick question. So
sure.
I wrote a paper on this topic, and in my research, one of the problems I struggled with was this idea that a lot of these accounts we're talking about, if you go in and read the fine print, many of them actually expire when their users do, that they're contracts that when you actually clicked it accept, you didn't realize that you were actually saying, okay, when I die, my Facebook ceases to exist. But all the content is explicitly owned by the user.
Yeah.
So
and the tech companies haven't thought this through.
No one's thought it yet, so I don't know the answer.
And they're not, it hasn't been thought through, absolutely. Certainly the law that we do have is pretty explicit, that the executor steps into their shoes. They have a right to claw that back. And certainly if they choose to delete it, one could argue that that makes them an executor just on tort and legally liable for doing so. So they're running a risk, irregardless of what the contract says, right? And those contracts, I would suggest, are of questionable enforceability anyways. I mean, they're no different than when we studied contract law, Tilden Rent-A-Car, which the court basically said no, because you don't have time to read it. You didn't read it, so why should we're not going to hold you to it. And I would argue that you click, 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 click. You didn't read it. You have no interest in reading it. Are you really bound by it? sorry, whoever wants to duke it out.
I'm just going to make a comment about this.
Sure.
I actually think that the tech companies have thought about it. And so, like, for example, Facebook won't
has a lot of them.
delete your information even if you delete your account. And I think one of the reasons why they do that is because of this reason that,
Well, they thought about it in the sense that they memorialize, but there isn't really a process of extraction that's easy. So, in a sense, you have to, if you want to abide by, you almost can't abide by the Facebook's rules. If you as an executor are determined to extract whatever digital asset out of your Facebook account that you need, you almost have to, at this point, cheat and go in on the easier to ask forgiveness than permission principle and extract that before they memorialize. Because once they memorialize, it's locked down. No one can get in or out of that account. So that's potentially a problem. The more circuitous route, of course, would be to go to court and force Facebook to hand over a DVD of it. But does anyone want to pay a lawyer $10,000 or whatever to do that in California? Well, I think you could probably argue to bring it in Ontario, but to do that for photos that may have huge sentimental value, but zero financial.
But a lot of them have terms, like in their terms, they'll state what will happen on death.
Yeah,
right.
But we also have to question the legal enforceability of those as click-through contracts, right? Whether or not they're truly enforceable. Again, whoever wants to. Should we give up on hands and just shout?
Just shout out. Secondary wills. Let's do a question about that. The whole secondary wills are a relatively new idea. They came to effect because Ontario boosted up its probate fees to make it worthwhile. So when people found that they didn't have to load all of their valuable property into the one will and pay probate and take it out into a non-probate will, then that was going to be worthwhile in certain cases, and especially if you have a company. And so if you have a company, I can see the websites, everything else would go through that. But so it's basically it's financial considerations to avoid probate that brought secondary wills into effect or into existence, and that's the reason people have them. Or is it? I mean, would a privacy issue also be? Do people have secondary wills for privacy reasons?
Sure, right? Because if you have to take to probate, as soon as you take to probate, it's a public record. Anyone can go in and pay, go to the court office and pay and get a copy of it. And a lot of people don't realize that, but when they do, that becomes an issue. And I think with digital legacy issues, I think it'll become more of an issue in terms of privacy, right? You don't necessarily want someone to know that you have a Ashley Madison account, for instance.
Clean living, that's what we
Yes.
Do you know any sites that actually have a good policy? I'm now really concerned, and I'm really glad you do this session because this awakens me to an issue that I hadn't even thought about. I have artist clients who may actually become more valuable after death. Their works, and they clearly would want their sites maintained. So, have you got anybody that's good out there?
They either haven't thought about it, or if they've thought about it, they've thought about it like Facebook has, and it's a bit unreasonable. Well, reasonable to them, but not reasonable to us.
And they're not fixed anyway.
And they're not fixed. Changed at will, of course. So no, that's the huge risk. That's yet another. I hadn't thought of it in that sense before, but you're absolutely right. Michael Jackson's Facebook page, that's going to have a huge value to it.
Well, this is a visual artist, and she currently sells her work that way. She definitely want her estate to continue to sell her work, which again would become more valuable.
Well, the problem is
if it's a Yahoo scenario, instantly it would be gone, right? If so, are there sites where that isn't the norm?
I can't think of anything off the top of my head, but they're never going to write it. They don't want to open that can of worms, so they're not going to write it that way as a rule of thumb.
You just wonder, though, that artists are in business often, and whether you can use a corporation for that.
That would be good.
So you end up with your digital assets corporately held, that holds the account, that doesn't die. And so it's
Facebook
some
doesn't
planning
allow
that sets you up to transition debt. So your literary executor, hey, takes care of the artwork in physical form, but your corporations and your digital assets carry on.
Yeah, for sure. I mean, there are challenges on whether the account will allow the corporation to hold an account, but then you just shop around for the right account.
The right executive.
Yeah. Well, that's true in so many ways.
For those who are interested about the tax aspects, I refer you to the website of the Private International Law section of Justice Canada and the Hague Convention, the Hague Conference on Private International Law. They are really the specialists on these issues.
So we're rapidly running out of time. It's been fun. Let me just skip through. I think most of it's been covered, but I mean, essentially, we've talked about it. We haven't really talked about the executor's role, but the risk of confidential information. Of course, confidential information in and of itself isn't protected, so you have to be really careful about confidential information because confidential information can't be the subject of a taking within the criminal code. We didn't really touch on online liabilities that you might have to deal with. But the rest we've dealt with. And then questions, which I guess we've dealt with. So any last questions before?
We need law reform? We need a statute?
I think we do. I think we do.
Okay, well, I think that kind of thing, so let's chat.
Absolutely.
Thanks, Daniel. That was great.
You're welcome. Thank you.